चलो आ जाना। तुमने सही बोला।
I am praying for leave to file a memo appeal without certified.
Yes, leave
My
granted.
lord, same prayer, my lord, leave to
Same
prefer
thing.
appeal without certificate.
My lord, under grounds of urgency, I want to upgradation of this case.
Immediately after vacation, it will be done.
Your Lordship, I'm seeking leave to file this and move it tomorrow. This is pertaining to the minor girl's rape and murder, which has been reported on Friday.
I also, my lord, file one same.
No, yesterday some order.
That
That-
order
I have annexed, Your Lordship.
Oh, my lord, passed an order regarding my lord
Postmortem.
at Kolani Ames. My lord, most unfortunate in the order also, my lord, no POCSO case
No,
is
no.
started.
You can't comment upon that.
No.
Come on.
Not put the order.
If you are aggrieved by the order,
Lordship,
no. If you are aggrieved by the order,
No,
you
not
file an
agree,
appeal.
not agree. Your
part
Lordship,
of the-
actually,
No, my
both it
lord.
out.
Madam, look here.
Please.
No, wait.
Unfortunate part of the police authority. My lord, one line means, my lord, police authority, because
Then you go before the very same
No,
bench.
but
Nothing can be
that matter.
No, leave can't be granted. The investigation is just commencing. Now, Supreme Court very recently set aside a judgment of the High Court of Calcutta on the ground that no reasons were there as to why the investigation had to be transferred to CBI.
My lord, no, my lord, police authority on the very first day.
Police
reopening-
failed.
On the
Police
reopening
failed
day,
to-
on the reopening date, you file
My lord,
or you move the
Your
vacation.
Lordship, the problem is that the police had failed to register POSCO.
Yes.
There
That
a
is the
direction.
problem. It
That
was
is
the
our
honorable
case.
court's intervention that it was included.
So therefore,
And that matter is filed by state,
Not
Very
our,
nice.
not by us.
not
who are you?
My lord, my lord,
Who are you?
the present petitioner is the, my lord, one of the my lord,
No. If
public spirited person.
if it is a victim's family, that's something different. All this public interest, public spirited person, law abiding citizen, what is it, of the country, this, that, first paragraph, income tax assessee, all
My lord,
these things.
Lordship, kindly give me.
Please wait. Let the postmortem be done. The court has directed the matter to report compliance on a particular date.
On
I read the order only
Your
in the
Lordship.
newspaper.
Your Lordship.
In fact, I granted permission on Sunday morning, where the learned judge was pleased to accept
up
the
the
suggestion and take up. Please wait for some time.
Allow us to file it and move it post vacation.
No, you file it post vacation. By then you will have better material.
Your Lordship.
All my lord,
Yes.
My lord,
That's over.
This matter is known to you in
Ah.
the month of March. This is
Ah.
regarding a temple,
Ah.
our family temple. My grandfather.
What do you want now today?
See, they have the trespassers, which the single bench have already.
We can, if you want, we can hear it.
Hearing either today afternoon, because I have already informed the.
No. Today afternoon, impossible, sir. Impossible.
Because my wife Septuagenarian, so she cannot enter into the temple. Now you see, every Bengali community and Hindu community.
You please give the letter. Let us see.
They are geared up for the festive.
You-
And our family temple, our date.
All right.
We cannot adorn the date with a new sari. So this is.
No. We have heard the matter once, twice, not by this bench, by the other division bench. It will be taken up after vacation. Please get the letter.
May I have?
Under grounds of urgency, I want upgradation.
You give the letter, sir. That's all. We can't ask you.
My lord, I would like to mention one matter, my lord. This is a contempt petition in respect of the reported judgment, the landmark judgment, Anish Kumar versus State of Bihar in 2014. My lord,
You file it.
my lord, the matter has already been filed and service has already been done, my lord. If the matter can kindly be listed tomorrow, because as
Let
otherwise
us see.
there
You
is
give the
reasonable
number, let
apprehension.
us see. You give the case number.
My lord, I have.
Let me see. Go.
My lord, may I have my lord's kind leave to mention
I'm-
that a public interest litigation,
Hmm.
that if your lordships are pleased to take it up tomorrow. This is, my lord, regarding the protest which is going on right in the middle of, my lord, the main thoroughfare in Calcutta, my lord, in Dharmotala. As a result, my lord,
Who is protesting?
my lord, some doctors are protesting. My lord, we appreciate the protest, but we only,
no.
my lord,
We can't do anything in the matter. The matter is now pending before
my
the
lord.
Honorable Supreme Court. Therefore, we have directed all other matters to go out of the list. Let us wait.
Only one indulgence. If they can, my lord, shift the protest from right in the middle of the road to the side of the road, then, my lord, traffic can pass. If that is possible.
We will not do anything. Please come back after
Very well.
vacation. Thank
My
you.
lord, I am praying for your lordship's kind leave to file an instant appeal without the certified
Yes,
copy.
leave granted.
Grateful.
My lord, may I have your leave to mention a matter for inclusion in the list? This is the regarding a contempt petition pertaining to violation of Anish Kumar guidelines.
Your Lordship, may I be permitted to mention the matter for urgent motion and tomorrow? Two appeal applications, Your Lordship.
Group 9,
Yes, Your Lordship. Residuary group 9. Yes, Your Lordship.
you file, let us.
We have filed, Your Lordship. We have filed
Give the number. If not possible, you move the first vacation code. We have got continuously, we have got vacation.
Your Lordship, because building is getting demolished and it's
Use the
authorized.
number, let us see.
Grateful, Your Lordship.
Seeking your lordship's leave, my lord, to file these paper books.
Yes, leave granted. Yes, please call.
Grateful, my lord.
Original side daily list item number 1.
I have put the state authority, my lord.
You are for the state. What is any instructions you have got?
No.
None appears for the petitioner. Dismissed for non-prosecution. Next.
But I was applying for the respondent KMC.
Yes, KMC, please give your appearance.
My lord.
Put it in the chat box.
My lord. Deeply obliged.
Now we move to the appellate side list.
I appear for the petitioners, Your Lordship.
Let him call out. The system has to be changed from original side to appellate side. Then only.
Daily list, serial number 1.
Yes.
I appear for the state respondents, my lord.
Yes, AG. There was some report was required to be
Yes,
filed.
yes, I'll tell you, Lordship, my lord. Here, my lord, this relates to, my lord, Manrega scheme. My lord, on the last occasion, Mr. Bhattacharya, my lord, had made a submission that no work is being provided to the job card holders.
Yes.
On that, my lord, I was to take instruction. My lord, if your lordship may kindly, my lord, have a look to, my lord, a letter which is part of the record, my lord. I don't want your lordship to offend for it, my lord. We have got copies of that letter. If my learned junior can hand up to the court. But this is a letter, my lord, of the central government of 9th of March 2022. My lord has a copy, my lord?
Yes, sir. I've given him the copy.
Yes. My lord, if your lordship may kindly take, my lord, paragraph number 10, instead of, my lord, troubling your lordship with the entire order.
Your Lordship, it is a part of the record. It's in supplementary affidavit.
Already, when you got one copy, you could have taken one more copy. In the light of the above, due to non-compliance of the directives of central government in general, and action taken report for several central teams visited so and so. Decided central government as per the provisions of sections 27 of the Act, release of fund under so and so will be stopped.
Yes.
The issue of this order until the state government ensures compliance of the directives.
Yes.
Further,
So, my lord, by reason of this letter, my lord, we are stopped from, my lord, operating the scheme.
sir,
I'll tell you.
Learned Advocate General,
Yes,
the reason for stoppage appears to be
yes.
The state government has not complied with the directives of the central government.
Yes, my lord, on that, my lord, there. But I'll tell you, lordship, my lord, since, my lord, April 2022, but this is a letter of 9th of March 2022.
Yes, this is the old letter.
Yes, now, my lord, since April 2022, my lord, 49 visiting teams of the central government had come. My lord, they did not find, my lord, any substantial, my lord, irregularities. My lord, we have sent 21 action taken reports to these visiting teams. My lord, there has been no response on their part that we have defaulted or whatever of anything of that sort.
No,
in fact,
Advocate General, I think because the other bench was hearing the matter, I remember having referred to this letter.
Right.
Of 9th of March 2022.
Right. Yes, sir.
And that is in our order dated.
But there are several orders, which record
6th of June 2023.
Right.
Now, what is the central government instruction?
Your lordship, Kali takes your lordship order on 18th of January 2024.
18th January 2024. Yes.
Paragraph 2, my lord, if may I just place it? The London Additional Solicitor General has drawn our attention in the evidence in opposition file in WPA 555 of 2022 by the by the respondent number 1 and 2, shown by the Secretary Principal and Rural Development Department. In page 31 of the said affidavit, it has been submitted. Till date, an amount of rupees 2 crores has been recovered in respect of the findings of the team against the target of 613.14 crores. Then, Lord, thus it appears that the team on verification found the bogus claim have been made and recovery said to have been affected. If that be so, it is not clear as to whether the amount so recovered has been disbursed to the genuine cardholder and there has to be road.
No. Sorry for interruption.
Yes.
Sir, there are two links to it.
Yes, yes.
One is with regard to payments made to fictitious persons or non-eligible persons. There was a direction given. The team went again and found out that X amount of money was wrongly disbursed,
Yes.
directed to be recovered, part of it recovered. Out of 613 crores, about
Right.
210 lakhs alone has been
2
recovered.
crores have been recovered.
So the court was concerned, if it has been recovered, should you not disburse that amount to the eligible people who have really worked for these 100 days? That is one aspect.
Yes.
That didn't take place, etc. We constituted a team. Today, the nodal officer is supposed to file a
Well-
report. As per the order dated 26th of September, if you see page
No, my lord,
paragraph
your
1,
lordship, my lord, can you take the last order passed by your lordship? That is on, my lord,
26.
26.
Yes.
My lord, paragraph 9, page 4. The London Advocate General is directed to get appropriate instructions from the competent authority in this regard, and report shall be filed in the form of affidavit by the said authority. Now, my lord, paragraph
No,
18.
you come to para 2 of that order
Yes.
or para 1. In terms of the order dated 18/4, the Chief Secretary of the Government of West Bengal was directed to nominate a nodal officer.
Right.
It's required
Yes.
to coordinate the meetings of the committee, and there was also a direction for a report to be filed
in this
as regards the progress in the matter. Learned
Right.
Advocate General appearing for the state submitted that on the next hearing date, a report will be filed by the nodal officer after taking appropriate instruction from the committee. That report is not on record.
Your Lordship.
What, Advocate General, sir? That report is not on record. Nodal officer's report. Today,
Milord, Milord, I have to take instruction on that one. I'm so sorry, Milord. Today, Milord, the matter was made returnable, but only for this limited purpose. Therefore, Milord, I did not take that instruction.
May I only
Lordship.
indicate one thing?
no, you cannot, sir. You can't fall back on this 9th of March 2022 letter.
Milord, may I say this, Milord? If your
Milords,
lordship
may I
if your
respond
lordship
to
may
this,
kindly
your
have a
lordship?
look to, Milord, a few provisions of the Manrega Act. Milord, kindly, Milord, have a look to the Manrega Act, Milord. But this is a central government funded scheme where, Milord, the payments come from, Milord, the central government. Milord, kindly take, Milord, 4 sections.
No, sir, you can take a very clear stand
Yes.
that because of non-compliance in the past,
Yes,
central
Milord.
government has not released funds even for the present. If
Yes.
that is going to be a stand, then we ask the report of the central government as to why you are not releasing funds for the present.
Yes. Well, if your lordships may kindly consider passing an additional direction as to how they have dealt with our repeated letters to withdraw this letter of 9th of March 2022. If that additional direction could be, my lord, considered by your lordship to be passed, my lord, along with, my lord,
My lords,
whatever my
lords,
lord's
may kindly
proposes
take the
to
law
pass.
for a moment, my lord.
Pardon?
My lords, may kindly take the law for a moment.
Hmm.
Section 3, my lord. It creates a binding obligation on the state government to provide employment.
Sir, no,
Now, my lords, irrespective of whether the paymaster pays or not, it is an obligation on the state government to provide employment, your lordship. It is only, my lords, may kindly all see section 3 read with section 7, your lordship.
But along with, my lord, the sections which my learned friend wants your lordships to go through, please take section 22 also.
No, my lord, section 7 once again.
So your case is that irrespective of the fact whether the central government sanctions or not, it's an obligation of the state to
provide employment,
Right.
Your Lordship. Now, my lords, may kindly take the same letter, 9th March letter, Your Lordship.
section 22.
Yes, kindly have a look at section 22, where it says that subject to the rules made by the central government shall meet the cost of the following, namely, A, the amount required for payment of wages for unskilled manual work under the scheme, up to 3/4 of the material cost of the scheme, including payment of wages to the skilled and semi-skilled workers subject to the provisions of Schedule 2. Then 3 is such percentage of total cost of the scheme as may be determined by the central governments towards administrative expenses, which may include the salary and allowances of the program officers, his supporting staff, administrative expenses of the central council, facilities to be provided under Schedule 2, and such other item as may be decided by the central government. Then subsection 2 says, the state government shall meet the cost of the following, namely the cost of unemployment allowances payable under the scheme, 1/4 of the material cost of the scheme, including payment of wages to skilled and semi-skilled workers, subject to the provisions of Schedule 2, then the administrative expenses of the state council. Therefore, the funding pattern goes to show that the majority of the burden is to be shared by the central government. Now, if your lordships may kindly take the schedule. In the second schedule,
Section 23 and section 27.
Yes, I'll come to that. Please take the Schedule 2 under the Act, paragraph 29 of Schedule 2. This is wage payment. In case of payment of wages is not made within 15 days from the date of closure of the master roll, the wage seeker shall be entitled to receive payment of compensation for the delay at the rate of so and so of the unpaid wages per day of delay beyond the 16th day of the closure of the master roll. Any delay in payment of compensation beyond the period of 15 days from the date it becomes payable shall be considered in the same manner as delay of payment. For the purpose of ensuring accountability in payment of wages and to calculate culpability of various functionaries or agencies, the state will divide the process leading to determination and payment of wages into various stages such as measuring of work, computerizing, etc., etc., and specify the stage-wise maximum time limits along with the functionary or agency which is responsible for discharging the specific function, then computer system, etc. It gives the detail. Now we are coming back to the statute or the main sections. Please take section 27 now. Power of the central government to give direction. The central government may give such directions as it may consider necessary to the state government for effective implementation of the provisions of this Act. Without prejudice to the provisions of subsection 1, the central government may, on receipt of any complaint regarding the issue of improper utilization of funds granted under this Act in respect of any scheme, if prima facie satisfied that there is a case, cause, and investigation to the complaint made by any agency designated by it, and if necessary, order stoppage of release of funds to the scheme and institute appropriate remedial measures for the proper implementation within a reasonable period of time. Therefore, we are going and two subsections of section 3, at the end. Kindly come back to section 3. Subsection 2 says, every person who has done the work given to him under the scheme shall be entitled to receive wages at the wage rate for each day of work, save as otherwise provided in this Act. The disbursement of the daily wages shall be made on a weekly basis or in case not later than a fortnight after the date on which the work was done. Therefore, going by this Act, the spirit of the Act is, this is a central government sponsored scheme. The majority of the burden of the payments are to be taken by the central government. A very minuscule percentage is shared by the state government. Therefore, in the backdrop of the letter of 9th of March 2022, despite our best intentions, we cannot provide job because the wages will not come in view of the 9th March letter. Therefore, as my lords were proposing to direct the central government, I was only paying for an additional direction that let them clarify before the court that what we have done after the 9th March letter and what steps or decisions they have taken on our repeated letters. We can place those letters on record where we have requested for withdrawal of the 9th March letter.
Yes.
But these are my submissions for the present.
One issue. Section 22 has got two limbs.
Yes, Milord.
The subsection 1 deals with the obligation on the central government.
Right, Milord.
A says the amount required for payment of wages.
Yes, Milord.
Read with section 27, they are entitled to cause an inquiry,
Right.
suspend or do, they have got power.
Yes, Milord.
Subsection 2
Yes.
is independent of subsection 1.
Right.
Which deals with the state shall meet the following, namely, A,
Yes.
the cost of unemployment allowance payable under the scheme. So you
Right.
start paying unemployment allowance. Suppose wages central government is not releasing because they have invoked subsection 2 of section 27. Let the proceedings are going on. Then you let the state discharge its obligations under subsection 2 of section 22.
Milord, may I, Milord, make this humble submission before your Lordship, Milord? Milord, unless, Milord, the Manrega scheme or the act is implemented or implementable as a whole, please consider, Milord, whether, Milord, subsection 2 of section 22 can operate without subsection 1 in operation. Milord, may I make this submission, Milord, as a proposition of law? Milord, please take, Milord, the opening words of subsection 1.
Subsection 2 says the state government shall meet the cost. So
Right.
therefore, subsection 2 is not dependent on subsection 1. Subsection 1 deals with payment of wages for unskilled manual workers, workers under the scheme. Subsection 2 deals with cost of unemployment allowance. Now, you are not able to provide jobs because of the order passed by the central government, withholding the funds, inquiry going on, etc.
Yes.
Therefore, if the wages are not given or employment is not given, it goes without saying that they are unemployed. So the state should release the unemployment allowance, which it is not dependent upon the central government sanction.
Milord, my very humble and respectful submission would be, Milord, if your Lordships may kindly come back to, Milord, section 3, subsection 1. Milord, please consider, Milord, whether, Milord, the state's obligation can be, Milord, enforced without the central government, Milord, doing its part. Because this is, Milord, a central government scheme that unless, Milord, the central government operates, Milord, possibly subject to correction, Milord, the state government cannot operate. Kindly take, Milord, subsection 1 of section 3. Save as otherwise provided, the state government in such rural area in the state as may be notified by the central government, provide to every household whose adult members volunteer to do the unskilled manual work not less than 100 days of such work in a financial year in accordance with the scheme under this act. Therefore, Milord, for the scheme to operate under the act, Milord, it is for the central government to notify an area. So, Milord, everything, Milord, or Milord starts operating, or Milord, the ball is set in motion only, Milord, pursuant to, Milord, section 3, subsection 1. Therefore, Milord, the sharing part, Milord, the what are the benefits, then, Milord, money coming, disbursing, if there is a case of
Sorry for interruption.
Yes,
there is a clear demarcation between wage and allowance.
Yes, I quite follow.
That is evident from section 22 as well as section 6 and 7. Section 6 stipulates the wage rate and 7 for payment of unemployment allowance. Unemployment allowance, it's the duty of the state government to do it under the scheme. Whether you get the funds or not, it's not concern of the so far as the act is concerned. And
Milord, I'm sorry, Milord. I'm sorry.
But where
Milord,
is the report of the nodal officer?
Milord, please take, Milord, section.
May I only indicate one
Milord,
thing,
if I may, Milord, make 2 minutes submission, Milord. Kindly, if my Lord can allow me 2 minutes time, Milord.
Yes,
Milord,
yes.
Milord, please take, Milord, section 7 on the unemployment allowance aspect.
Yes.
Where it says if an applicant for employment under this scheme is not provided such employment within 15 days of receipt of this application seeking employment or from the date on which the employment has been sought in the case of an advance application, which is later, he shall be entitled to a daily unemployment allowance in accordance with this section. Therefore, my lord, unless the scheme is in operation, the persons cannot apply. And if they cannot apply, my lord, then the question of, my lord, providing jobs or failing to provide jobs, my lord, in my very humble submission, cannot apply.
No,
Therefore,
no,
my
sir,
lord,
the scheme has not been suspended. The
my lord, please have
payment
a
of
look. Yes,
grant
May I-
given by the central government towards
yes,
wages has been put on hold.
yes,
Your Lordship.
So therefore, the plain simple reading of the statute will show that
yes, my lord.
if you are unable to provide employment
Yes,
for any reason, the reason here is because central government has not sanctioned the fund, it has stopped the funds, inquiry is going on. Then
yes,
it goes without saying that these people are unemployed. The unemployment allowance has to be disbursed in terms of section 7, read with subsection 2 of section 22 by the state government.
my lord, my lord, if I may, my lord, once again, my lord, trouble your lordship, my lord, with the 9th March letter.
9th March, what happened is after 9th March, the AG says that some 24 compliance reports have been submitted. You are sitting tight on that.
So far as my lord, 9th March order is concerned.
After 9th
After
March.
9th March, my lord, so many things has happened, my lord.
No, so many things have happened here.
Yes, yes.
But what the learned advocate general says is they have given you compliance report. Either you decide or not decide. You come to subsection 2 of section 27, the last three sentences.
Yes.
But if necessary, order the stoppage of release of funds to the scheme and institute appropriate remedial measures for its proper implementation within a reasonable period of time.
Yes.
So you can't be sitting tight on that. Either you say that the compliance report is no compliance or partial compliance, or for XY reasons I can't accept. You pass an order.
Yes, yes, we'll do that. So far as that part is concerned, my lord, your lordship, my lord, kindly consider, my lord. My lord, inquiry is being conducted, my lord, your lordship has set up an inquiry committee also.
That inquiry committee supposed to give a report to
Report.
its nodal officer. That report
The
is not
report
there.
is not coming. And not only that, my lord, if your lordship, my lord, kindly see whether on the last occasion it was
And
submitted.
who's the nodal officer, AG?
Your
Yes,
Lordship,
we
I'll
have
just, Your Lordship, it's the Additional Chief Secretary, Finance Department, Your Lordship.
Yes.
He could have made a one-page report at least.
Yeah.
This all happened. The committee met on these days. This is how we have proceeded. That is why this matter we listed it today on the eve of the vacation. Why?
My lords, may I only indicate one thing, your lordship?
What do you want to
My lords, may
indicate?
kindly take the order dated 9th March once for a moment.
9th March is.
Please, once for a moment, your lordship,
Yes,
just for my satisfaction.
read.
Now, 10.2, my lords, reads, further, the fund transfer orders for wage payment generated from the date of this order will be paid by the state government from its own resources, and it will be continued till necessary compliance with reference to point. Therefore, my lord, it's essentially...
That they are challenging. See, the state is challenging that. You remember, not the present learned advocate general, his predecessor in office, said that that portion of the order we are challenging. Whether they can pass such an order is an issue. But by then what happened? Crores and crores of money went elsewhere. Whole thing got derailed. Several directions issued from time to time.
My lords, my
All right,
limited
please
cases,
complete.
your lordship.
Wait.
My limited cases, your lordship. I have right to. I have.
Wait, sir, nothing
My
can
lords,
happen overnight.
my lords, may kindly allow me to make my submission for a moment, your lordship.
Yes.
My limited submission is, your lordship, I have statutory right to walk. This is protected under section 3, read with section 7. My lords, I cannot be deprived of my right to work because of the differences between central government and state government. This must go on. Work must go on under Manrega. Whether the central government pays them or not, that's not my concern, your lordship.
No, in terms of wages, central government has to release. In terms of unemployment allowance, we put it to the AG, let the AG make a submissions on that. Why we can't issue a direction?
My lords, pending decision on this particular issue, whether central government has competence to issue this direction on section 27 or not, shifting burden from the central government to the state government, let the walk start, your lordship.
All right.
Sir, may I submit one thing? My lord, paragraph 5 of your lordship's order, my lord, it was submitted on the last occasion. It is submitted that for the nearly 2 years, no job have been allotted, as a result of which people are suffering. So, my lord, for the last 2 years, my lord, state government is...
You are also sitting tight on their compliance report. You have not passed orders. You tell them that this is no compliance at all. We are not accepting your compliance report. You pass an order. reference may be made to the order dated 26/9/2024. In paragraph 1 and 2 of the said order, there is a specific direction to the nodal officer who was nominated by the state government, nodal officer of the committee which was constituted, to submit a report. However, submit a report after taking appropriate instructions from the committee so constituted. However, no report has been submitted today. The learned advocate for the writ petitioner would contend that in terms of the scheme of the act, regardless of the fact that the central government have not released funds under the scheme, it is the obligation of the state government to provide employment and also pay wages. This issue needs to be adjudicated. Prima facie, on going through the relevant provisions of the Act, more particularly Section 3, Section 6, Section 7, Section 22, and Section 27, read with Schedule 2, there are two distinct aspects which is provided under the scheme. One is for providing employment for which wages have to be disbursed in terms of the wage rates stipulated in Section 6 of the Act. The other is payment of unemployment allowance in terms of Section 7. It is not in dispute that the central government has exercised its powers under Section 27 of the Act and has passed an order on 9/3/2022 stopping release of the funds under the scheme to the state government. Until the state government ensures compliance of the directives of the central government with respect to the inquiry reports of the central team led by the joint secretary within bracket RE and director RE within bracket RE. Further, there is a direction that the fund transfer order for wage payment generated from the date of the said order, namely 9/3/2022, will be paid by the state government from its own resources, and it will be continued till the necessary compliance with reference to the above condition. Full stop. The other direction is the pending wage payment and material payment, if any, prior to the date of the order, dated 9/3/2022, will be released by the central government. The learned advocate general appearing for the state submitted that more than 20 compliance reports have been submitted to the central appropriate authority of the central government pursuant to the orders dated 9/3/2022, and the state government has also contested the direction issued in paragraph 10 within bracket 2i's of the order dated 9/3/2022. The learned advocate appearing for the central government is directed to get specific written instructions as to what orders have been passed pursuant to the reports submitted by the state government, which according to them are compliance report pursuant to various directives issued by the investigating team. This report should be positively filed by the concerned officer on the next hearing date. The next aspect is, please strike that out. As pointed out earlier, in our prima facie view, there are two aspects under the scheme. One is payment of wages and another is payment of unemployment allowance. It is the submission of the learned advocate general that unless and until the funds are sanctioned by the central government, the question of payment of unemployment allowance by the state would not arise. In our privacy view, we are unable to persuade ourselves to accept the said submission, since the Act makes a clear distinction between payment of wages for the work allotted and payment of unemployment allowance. So as on date, the employment has not been provided by the state, citing the reason that the central government has stopped releasing funds. If that be the case, it goes without saying that the people are unemployed. If people are unemployed, in terms of section 7, they are entitled for unemployment allowance. And subsection 3 of section 7 states that the liability of the state government, subsection 3 of the section 7 fixes the liability for payment of unemployment allowance on the state government. This being a prima facie view, we direct the state government to answer as to why a direction should not be issued to the state government for payment of unemployment allowance, since admittedly employment has not been provided to the unemployed for the past 2 years. Full stop. Thus, the following directions are thus: in terms of the order dated 26/9/2024, the nodal officer of the committee has to file a report. Full stop. The appropriate authority of the central government has to file a report with regard to the stand taken by the state government that they have submitted more than 20 compliance reports pursuant to the order passed by the central government on 9/3/2022. And thirdly, the state government shall answer as to why a direction should not be given to the state government for payment of unemployment allowance. List the matter on so and so date.
Let's me kindly
Well,
record
it
my
appears
submission.
that along with
Let's me kindly record my submission.
Yes, I have recorded. No?
No, regarding resumption of the scheme,
Ah.
my lords, I submitted specifically that because of the departmental differences between central and state government, Manrega Act cannot, implementation of the act cannot be withheld.
The learned advocate for the writ petitioner could contend that though there may be differences between the central government and the state government, the operation of the scheme under Act 42 of 2005 cannot be put on hold. This aspect will also be considered on the next hearing.
Deeply grateful.
This matter will appear along with WPA 555 of 2022. Subhendu Adhikari is matter tag matter.
WPA 555 of 2022, where a detailed report was filed by the Rural and Employment Department, pointing out huge irregularities.
All right, you give that number.
My lords, under the same caption, your lordship.
Yes. Same caption, it will come above in the High Court at Calcutta.
Aye.
Above that, it will be.
I'm fully aware of my lord's constraints.
What to do?
I'm grateful, my lord.
Sir, my costly counsel here. No. Costly. Yes. Next.
Serial number 2.
Please, my lord, I appear for the petition.
Morning, my lords. Morning,
Yes.
my
My lord, I appear for the state, my lord, in this matter also, my lord.
Now, what are we to do today?
My lord, there's a very short issue over here because the Supreme Court is covering the CBI is now investigating the bulk of what's happened in that very sorry incident of 9th August.
I think my friends have just served us a supplementary affidavit, my lords, late this morning. We'll need to read the affidavit and respond to it.
So this is it's only an amendment of a prayer, and
But we
nothing more.
don't know all of these things, my lords, when it's served 20 minutes before the
Madam,
hearing, my lords.
Learned Senior Counsel Mr. Jethmalani mentioned
My lord.
that is, in fact, we sought for a clarification
My
that
lord.
when the Honorable Supreme Court is seized of the matter, whether this court can adjudicate this issue. Then Learned Senior Advocate submitted that they have sought for clarification, and the Honorable Supreme Court was pleased to clarify that all other issues can be raised in the before the High Court. But as of now, the bunch of matters have gone out of the list, and we have said that liberty to mention as and when the matter as per the direction of the Honorable Supreme Court. So we want to be doubly sure that whether there is any order to that said effect, or it was an oral clarification.
My lords, the order is now out of the Honorable Supreme Court. It does not specifically speak to Mr. Jethmalani's petition in any which way, my lords. Though Mr. Jethmalani has an IA pending there in the Supreme Court and his 2 writ petitions here, and now a new supplementary affidavit, which he's moved about half an hour ago and served all of us. This is the situation, my lords.
So that we can give grant time. In
Yes.
fact, when he mentioned, we requested the counsel on record for the senior counsel to inform your good self so
Yes.
that you
I'm
can
so
also
grateful,
be,
my lords. I'm so
you can
grateful.
be present.
Yes.
But sir, one small request.
Yes.
Can that some order in writing, if you can be able to obtain, just
Yes,
to
my lord, I asked the Supreme Court. I'll tell your lordship what happened. Miss Guruswamy was present there, and the court pointed out that Miss Guruswamy is present there, and the assumption being that she would tell your lordships what happened in court, but she's only revealed part of what happened. If I may
That's
say
not
so.
correct, my lords. My
You,
friend is
Miss
obviously-
Guruswamy, you can reply to me. I regret you've taken this partial.
This is misconstrued of what has happened. The court saw Mr. Jethmalani twice or thrice brought it to the notice of the court. The court heard him and moved on. This is what happens in these hearings, which are so crowded.
all right, madam.
No,
Today,
1 minute. Miss Guruswamy,
all right.
I'll take it. Please record what Miss Guruswamy says. I'll tell your lordship about what happened. This is my view of the matter. The court said that Mr. Jethmalani, the only thing that we have transferred to the CBI is the investigation of the rape and murder and nothing else. And I don't think, and it said that the Calcutta High Court should be aware of the scope of what we have transferred. Ms. Guruswamy was there. And they point specifically told me Ms. Guruswamy is present in court today. That is in the Supreme Court. And I think impliedly it meant that Ms. Guruswamy would tell the court that this issue about the police commissioner of the state of West Bengal, of Calcutta, sorry, of the city of Calcutta, having revealed the name of the rape victim, was very much within your lordship's remit. They said that it's not necessary to, I asked them twice, why don't you all do it in writing? They said, Mr. Jethmalani, it's not necessary. And well, this is the point in paragraph 6 of the Supreme Court order. I will point out what the Supreme Court has said. The Supreme Court in paragraph 6 said, to answer Ms. Guruswamy's, my lord, reticence, the CBI, as it appears before this court,
This is all
the
unnecessary.
CBI, as it appears before the court, is conducting an investigation on 2 facets. That's all. The alleged rape and murder which took place on 9th August 24 at RG Kar Medical Hospital, College and Hospital, and 2, the allegations in regard to financial irregularities, which were also entrusted for investigation by the CBI by the orders of a division bench of the Calcutta High Court. There are only 2 issues, very clearly specified. And my lord, I don't think we need any. This matter admits of no doubt whatsoever, notwithstanding Ms. Guruswamy's statement that Mr. Jethmalani mentioned it thrice. The court said there is no need to do this because...
My lords, we are happy to appear before my lords. It would be a great honor to clarify this issue before my lords. All I'm saying is, since Mr. Jethmalani has dutifully served us late this morning
That's a separate issue.
Supplementary affidavit, I didn't interrupt you, Mr. Jethmalani. Please don't interrupt me. Please don't interrupt me. Please don't interrupt me.
Sorry, I'm bound to interrupt you because...
My lords, all I'm saying is, we're just asking for some time to respond to these various supplementary affidavits that he keeps filing. This is all I'm
sorry.
saying.
There are not various supplementary affidavits.
No, I mean, there are 2 petitions
I'm really
here.
sorry. There's only one.
You know,
There's only
would
one
like
amendment that has been made to a prayer.
My lords, I'll let him continue, my lords.
You let me
I'll let him
because
continue.
you are
sir,
repeat.
Please go ahead.
I do not understand this. One of the commissioner of police.
Sorry for interruption.
Yes.
So the procedure here is
Yes.
In the Calcutta High Court.
Yes, Mana.
When you have to bring on record a document or something, a supplementary affidavit is filed and the document is annexed to it.
Yes.
And if there is an amendment of prayer in my parent High Court, they take out an application for amendment of prayer.
Yes,
here
but...
they take out an application in IA CAN number so and so.
Yes.
For giving a supplementary affidavit. In the supplementary affidavit, there is a prayer. Please amend prayer A of my petition as so and so.
Yes.
So whenever it comes up, the dusty is there. That is advance services required to be complied with.
Yes.
And court generally grants an opportunity to the other side to respond to whatever prayers they want.
No difficulty. No difficulty.
There are 2 things, sir.
Yes, sir.
One is whether the concerned commissioner, the then commissioner, who is implemented by name in this writ petition,
yes,
desires to file an affidavit.
Correct. That's for the state to tell us.
Because, madam, if
I'll have to take instructions on it, my lord. I follow. I bow down. I appreciate what my lords are saying.
yes, because
Yes,
he
I'll
has
have
to
to take
take,
instructions.
take a stand, a clear
Certainly.
stand.
Certainly, I'll take instructions.
There are three respondents in the writ petition.
My
One
lord.
is, the first is the then Commissioner of Police. The second is the Secretary Department of Home and Hill Affairs, West Bengal, State of West Bengal.
Yes, my lord.
Third is the Ministry of Home Affairs, Government of India.
My lord.
So now which, the first respondent will have to file an affidavit.
My lord, I appear for the state, my lord, or the respondent number 2. But I also, my lord, wish to, my lord, respond to, my lord, whatever, my lord, Mr. Jetmalani's client has filed.
Yes.
Because
No,
I don't
that
have
is-
a copy of the
That is a
supplementary.
no, Learned Advocate General.
Yes,
That's a
ma'am.
supplementary affidavit.
Yes, ma'am, I
Probably,
follow. I
but
follow. I
there
follow.
are the allegations in the writ petition have
Yes.
to be answered.
Yes.
So the state can answer, the first respondent can answer,
Yes,
and the central government can also answer.
Yes, my lord.
Or
We
you
bow
say,
down. Absolutely, my lord.
if central government doesn't want to answer, doesn't want.
No, my lord,
That's their wish, my lord.
it is actually not belonging to the Home Department. It is actually belongs to the Department of Personnel and Training. Because the IAS and IAS officers are all allied officers. They come under direct control of the Department of Personnel and Training. So we shall have to take instruction.
What, Madam
We
Pandey?
will commend your lordship to that effect. By your lordship may grant
You
leave.
have implemented the wrong respondent.
Your lordship, we will make the necessary amendments. In appellate side, it is permitted to amend through the advocate on leave granted by the Honorable High
But
Court.
then they have to be served. The department, the
Your
concerned
lordship,
department.
the learned ASG shall
Already
only be
ASG is
giving-
a senior advocate, madam. So how you can serve notice?
I'll serve the Ministry of Law and Justice, your lordship.
Whatever is the procedure. And where is that supplementary affidavit? Namika, where
Your
is
lordship, this is the supplementary affidavit.
But my instructions are, my lord, it has not yet been served on my learned junior.
I see.
Who appears for state?
I am appearing.
You give one copy.
আচ্ছা দিচ্ছি serve করে দিচ্ছি এটা
But
scanned
sir,
copy has been served. I'll serve.
Sir, there is one earlier order passed by the Honorable Supreme Court. I remember two orders. The first order, in fact, when we first passed the order in the bunch of petitions,
Yes.
the lead case was the parents of the victim.
Yes. Yes, ma'am.
Where we had requested the electronic and print media
Yes.
that the identity or the name, etc., of the victim should not be disclosed.
Correct, ma'am.
And we also said to YouTubers, etc., please be responsible in doing that.
Yes.
And we also masked the names of the writ petitioners. That is, the parents of the victims were shown as XXX. We have that's been masked.
Yes.
Subsequently, when the matter was dealt with by the Supreme Court, I don't remember the date of the order. The Honorable Supreme Court issued some directions to
Wikipedia, my lords.
Wikipedia.
Yes, ma'am.
Yes.
Detailed direction.
That is one order we'd like to see.
Yes,
The
ma'am.
second, then there is another order which says that it is not restricted only to Wikipedia but extended to so and so so.
That's last time's order. That is the last order.
Last order date.
Your lordship, I have placed that order. I've
15th.
handed your lordship last order. I have handed over.
There are three of the last
Your
order.
lordship.
2 and 3. Your lordships may kindly see paragraphs 2 and 3 of that order. It is not confined to Wikipedia, but shall apply to all intermediates.
Yes, and the order prior to that was specific to Wikipedia.
That's
13
right.
days.
That's right. For
That's
once we are in agreement with this.
Yes.
So therefore, sir, prima facie, the Honorable Supreme Court is also conscious of, seized of the matter regarding disclosure of the name of the victim by
Yes.
either print or electronic media or maybe individuals also.
Yes, ma'am.
There is another writ petition
Yes.
filed by, I forget his name.
Tipti Pandey. Tipti Pandey and Apunna Banerjee. There are two petitions.
Two writ petitions have been filed. That also we have adjourned it along with the batch. Where
Yes.
one is regarding certain YouTube, not YouTube, WhatsApp, no.
Social media publication and displaying the photographs and
photograph of the victim with very, very obnoxious statements.
And we have filed a report pursuant to lawsuit direction.
Yes, and we directed
still
the
go.
Joint Director CBI to see what can be done about it. whether they can partner with the state cyber wing and do the
Yes.
investigation. But
And
that's,
my lord, in the last order, the Supreme Court had asked the Solicitor General through the Ministry of Electronics and Information Technology, this is paragraph 3, to nominate a nodal officer who shall in fact be the nodal officer to coordinate this, to deal with this unauthorized uploading of content of information pertaining to the deceased. That is paragraph 3. May I read paragraphs 2 and 3 out, my lords?
yes.
Yeah, the earlier order of the court, so this is the last order of this court shall, it is clarified, not be confined only to Wikipedia, but shall also apply to all intermediaries. To reiterate, no intermediary shall allow or carry the publication of the name of the deceased, her identity, photographs or videos, either pertaining to the incident at the R.J. Kaur Medical College or otherwise. 3. On the request of the court, the Solicitor General has stated that the Ministry of Electronics and Information Technology shall nominate a nodal officer to whom any communication in relation to the unauthorized uploading of content or information pertaining to the deceased can be intimated so that necessary action can be taken with the intermediary concerned for pulling down such publication or dissemination. And then, my lords, paragraph 4 is the status report on the CBI investigation. Now, all we are saying, my lords, is given that the Supreme Court is cognizant of this facet of the case, and given that we have been served with these documents so late in the day, we are just requesting some time to respond to all of this. So
No
we
difficulty.
can
No, I
take
am not
cognizance
objecting to
and-
that.
No, they are.
Object to that.
Mr.
Yes.
Jethmalani is not opposing, but
Yes.
Madam, prima facie on reading para 2 and 3,
My lord.
the Honorable Supreme Court is dealing with or issued directions not to do certain things,
My lord.
initially to one party, then
My-
extended to all intermediaries, then a recording Solicitor General submission
My
that how they can, what do you say, pull down this. But what about cases
Yes, my lord.
for which are prior to this, where names were disclosed, identity, because 2 other writ petitions are running in the list.
Yes, my lords, I must also say with respect, these 2 writ petitions are identical to each other. They emanate from the same law office. I'll just bring that on record and I'll inform my lords. They are cut and paste copies of each other. The lawyers come from the same law chambers.
It is not new to us.
My lord, what does one say, my
But
lord?
you can be
This
clubbed.
is
I have
the
no
state
difficulty
of
with it. It can
public
be clubbed.
interest litigation, my lord. This is the state.
Kindly, my lord, remember, pursuant to lawsuit direction in Tipti Pandey's case, where they are disclosing and publishing photographs of the victims. We, pursuant to lawsuit direction, the joint director filed a report in seal cover.
That's it.
The last
It's
of it.
still in the sealed
Yes.
cover. We have not opened that
Yes,
cover.
yes.
True.
But all I say is this, my lord. They make one final submission, my lord, and we can give time. I have no difficulty that the new. I didn't know there was a new amendment made, but there's a new amendment and a new affidavit. Of course, he's entitled to take time. But the fact of the matter is, my lord, 9th of August, the Commissioner of Police, I'm saying alleged, is alleged to have made this disclosure on the 9th of August. We are now almost on 9th of October. Almost 2 months have passed. Something should be done. Nobody from the state
And
of
this
West Bengal-
gentleman has since been transferred.
Again,
No, my lords.
with respect to you, Ms.
No,
Guruswamy,
to
let me
keep
just finish.
calling him
You
the
will-
Commissioner of Police.
I will give you a
He's
free.
decorated IPS officer. He has been transferred. You know, he has gone back to the rank he enjoyed in 2021. He has gone back to that rank.
I don't know about his rank.
I mean, there is Article 311 of the Constitution, Mr. Jethmalani. I commend it for your reading.
No, I'm not on his status
I
and his
commend
rank.
you to please read the
What I
Constitution.
recommend to you, Ms. Guruswamy, you
No,
read section
sir, in
72 of the new
page,
act, which is a criminal
60
offense.
page
He is committed
68
a
of
criminal
the
offense.
page 68 of the state petition is a
Yes.
cover containing a compact disc, a CD.
Yes.
Whether that copy has been served on all of you?
No.
No, my
I
lords.
think that contains the recording.
That contains the police commissioner's record.
Yes. So that needs to be served.
Yes.
We don't have it.
What, Amrita, you have not served this?
Lordship, that has not been served. I'll serve it today.
What is all this? You have given it,
Lords-
we have
Your
not
Lordship.
opened this cover.
Yes, my lords. We don't have this, my lords.
don't have
Also, I'm not privy to the amendment to their prayers either, my lords. I think these little
All right. The
procedural
matter,
matters. Yes.
the learned senior advocate, Mr. Mahesh Jethmalani had mentioned this matter before this court for an early listing. We had requested the learned counsel on record appearing for the writ petitioner to inform the learned advocates appearing for the respondents, including the learned senior advocate appearing for the first respondent. Accordingly, they have been informed and the matter is listed under the caption to be mentioned. The first clarification we wanted was whether this court can deal with the prayer sought for in the writ petition when the Honorable Supreme Court is seized of the matter relating to the RG car incident. It is a submission of the learned senior advocate appearing for the writ petitioner that a specific clarification was sought for from the Honorable Supreme Court, and it was and in the order passed by the Honorable Supreme Court dated
30th September.
30th September.
30th September. 30th September. In paragraph
6.
6, the facets, the two facets which were being dealt with by the CBI have been set down, namely 1I, the alleged rape and murder which took place on 9th August 2024 at RG Kar Medical College and Hospital, semicolon, and 2Is, the allegations in regard to the financial irregularities which were also entrusted for investigation by CBI by the orders of a division bench of the Calcutta High Court. Therefore, it is a submission that the aspects dealt with by the Honorable Supreme Court are the above two aspects, and this court could be this court can consider the prayer sought for in the present writ petition.
My lords, I'm so sorry to interrupt. May I just say this, and I apologize for interruption. These two paragraphs pertains to the width of the CBI investigation. The Supreme Court is also seized of the doctors' agitation and national task force is set up. The facet of the Supreme Court's remit in this matter is about 6 blocks.
We are just recording the senior advocate submission, madam.
Yes,
We are coming to that.
Grateful. I'm so grateful.
To be noted, the learned advocate the learned advocate on record appearing for the first respondent has handed over to us a printout of the diary number 37351 of 2024 of the Honorable Supreme Court, and it is pointed out that two applications have been filed in IA number 216487 of 2024, which is an intervention application, and IA number 216488 of 2024, which is for clarification / direction, and both the interlocutory applications are still pending. The learned senior advocate appearing for the first respondent would submit that yesterday, late in the evening yesterday, a supplementary affidavit has been filed by the writ petitioner, and they require time to respond.
It was given to us today.
Today morning, my lords. Today late morning. I in fact got it 20 minutes before the hearing, my lords.
Now, we got it.
They'll wish to respond to the said prayer. As we note that the application for clarification is still pending, we have genuine doubt in our mind as to whether this court would be entitled to proceed with this matter independently, dehorse the matter, which independently, more particularly when the Honorable Supreme Court is seized of the matter. We say so because the Honorable Supreme Court has also issued certain directions with regard to the disclosure of the name and identity of the victim, which is evident from paragraph 2 and 3 of the order passed by the Honorable Supreme Court dated 30th September 2024. For better appreciation, the same is quoted here and below. Page 9 of the Honorable Supreme Court's order, para 2 and 3. The above directions have been issued by the Honorable Supreme Court after having been apprised of the fact that the name on the identity of the victim is being disclosed by several intermediaries. The question would be as to the allegation made in this writ petition, which was prior to the orders passed by the Honorable Supreme Court, as well as prior to the order passed by the division bench of this court dated 13/8/2024. We give liberty to the respondents to file their affidavit in opposition not only to the allegations made in the writ petition, but also in the supplementary affidavit, as well as whether this court can independently proceed with the matter and consider the prayer sought for in the writ petition.
May I just say this, Malad? I'm sorry to interrupt you. That one of the allegation which we are seeking to canvass before, which we are seeking your lordship's jurisdiction, invoking that jurisdiction, is the criminal aspect of the disclosure made. That's specifically it.
It is a submission of the learned senior advocate for the writ petitioner that what is being canvassed in the writ petition is the criminal aspect to the disclosure of the name and identity of the victim. So far as the offending material, which according to the petitioner, please strike that out. According to the petitioner, the offending material has been placed before this court in the form of a compact disc, which is enclosed in a sealed cover in page 68 of the stay petition. We find the copy of this compact disc has not been served on the respondents. Therefore, there will be a direction to the learned advocate appearing for the petitioner to serve copy of the compact disc to the learned advocates appearing for the respondents during the course of this week. The learned additional Solicitor General appearing for the Union of India submitted that the third respondent is not the concerned ministry, under which the officers of the IAS and IPS cadre would fall, and submitted that the concerned ministry is the Ministry of
the Directorate of Personnel and Training.
Directorate of Personnel and Training, not Ministry.
We will add them as respondent 4, your lordship. Let the respondent 3 be there, your lordship. We will add them as respondent 4.
Liberty is granted to the petitioner to implead the said department, the said directorate as the fourth respondent in the petition, and copy shall be served on the concerned department as well as in the what is it called? Ministry of Law and Justice Branch Secretary.
Once again, 11 Strand Road. 11 Strand Road.
Branch Secretary of the Ministry of Law and Justice, Calcutta. So the affidavit shall be filed by the respondents within. Sir, we are closed from closing day after tomorrow. At least from 9th to 18th, nothing will work in West Bengal.
My lords, may I just make 2 submissions, my lords, at this
point?
No,
how much time would you require?
My lords, we'll need 6 weeks, my lords, because next month, this month that follows in West Bengal, my lords, most of my instructing lawyer friends are also on leave, my lords. So at least 6 weeks.
So it is an appropriate time, madam, for you to come here.
No, we welcome.
My lords, I always love coming to Calcutta, my lords. I love coming to Calcutta, but I've never invited my lords enough to come to Calcutta.
No. Why is this, sir?
I'll ensure that. First time.
That's a hint.
Mr. Banerjee is there. He is immediately extending invitation. Learned Advocate General is there. He will issue VIP passes to you.
No, my lords.
Yes. But in fact, my lord, if my lord the Chief Justice remembers, my lord, I had requested your lordship to stay back to Calcutta during this vacation.
I like to stay back, but you are filing so many cases, sir. Planning the Buddha,
But my
everything
lord,
you will see.
I must say that your lordship, the Chief Justice, is from my hometown of Chennai, my lords. So
We extended to Mr. Jetmalani also.
Yes,
Yes,
yes, of course, my lords.
I've been there. In fact, I've been to Calcutta.
I
very
know,
often.
we work together. No, Mr. Banerjee will not only send the invitation, he'll send the air ticket also. He can do it. He can do it.
Yes. My
All right.
lord, I would request 6 weeks, but your lordships will also see, my lords, that if my lords will hear this matter and are seized of it, then we will file this and proceed here, my lords. But your
No.
your lordships will make
Because
the decision, my
we will give a date on reopening. We let it appear under the same caption to be mentioned. Because the Honorable Supreme Court will deal with this matter on 15th October.
On 15th
Yes, my lords. Yes.
Very well. So therefore, on that day also, you can make submissions of. So list this matter under the same caption on 7th November.
And then we decide on the affidavit.
7th November.
Then we decide on the affidavit.
No.
Yes, so my
Very
lords,
well. Very well.
by
You can
on
file-
this on the 7th of November, my lords, we'll appear before my lords, and your lordships will then indicate, my lords, based on, because the Supreme Court
No,
would have
if
its
you
hearing.
can prepare this affidavit, because we are keeping things open. You are
Yes.
raising the issue that Supreme Court has seized of the matter. Mr. Senior
But
Advocate.
is that if that's the case of Ms. Guruswamy, that the Supreme Court is seized
All
of
right.
the matter?
No, I have no case on this, my lords. I am not making any case.
Then
Your
it should be
lordship has
recorded.
to
Because
decide.
if Ms. Guruswamy says that.
No, we'll
Your-
do one thing. We'll do one thing. Because 15th October, the case is being dealt with by Honorable Supreme Court. Lawyers will be there. No issue.
Yes, Mr. Jetmalani will press his case in the Supreme Court. We will.
No,
we
I will point out the court's order.
And by 7th, my lords, if the Supreme Court has taken note of this, in any case, by 7th, we'll file our reply before my lord.
Yes.
Yes,
Affidavit
my
in
lords.
op-
Everything will
affidavit in
fall into
opposition-
place, my lords.
Affidavit in opposition to be filed by 7th November.
Grateful.
2024.
Well, let it come up. Let them send it. Give it to us 1 week before that.
My lords, we are learning from Mr. Jetmalani, who serves us 20
No,
minutes before the hearing.
possible.
No, we'll list
I'm
the
not
matter.
responsible for that. But in any
No,
case,
Yeah, that you're right.
you
That
should not emulate bad habits, Ms. Guruswamy.
No, what we'll do is, instead of listing it on 7th, we list it on 14th, giving
Yes.
time for you to file a reply.
Grateful. Grateful.
Reply, if any, to be filed not later than 13th November 2024. After
Grateful.
serving advance copies on the learned advocates for the respondents, list the matter under the same caption on 14th November.
Subject
Grateful,
to.
my lords.
Obliged.
Subject.
I'm so grateful. My lords,
Yes.
wishing you a happy Dashera season, my
Yes,
lords.
yes. Thank
Both
you,
my
Mr.
lords and
Yes.
to Mr. Jetmalani and the Advocate General, my lords.
Yes.
Thank you. Thank you.
Thank you, thank you, thank you.
Best
Thank you,
wishes, my lord.
Yes. Thank you.
Obliged.
I'm grateful, man.
You keep this also in there.
Serial number 3.
My lord, serial number 3. Lord, item 3, my lord, I appear on behalf of the West Bengal College Service Commission, being the respondent number 4 and 5.
May I start?
What is this matter?
Quality policy. UGC regulation violated by
You use the mic.
UGC's regulation notification on 18 July 2018. It was violated by the Higher Education Department, Government of West Bengal. Not only that, as per the regulation that has to be enacted within 6 months from the date of publication, it was enacted after 2 years, 6 months. And the UGC notification is containing 55 pages, and the Higher Education Department.
But why affected candidate has not come? Why an advocate has come here?
Sir, I'm coming here because of the policy you have taken. Sir, a lot of students are affected.
No, they are all educated people.
Huh.
Not even one aggrieved person is before the
No,
court.
because a lot of people are affected because.
That
because
is true,
affected,
sir.
I'm telling you, sir.
If suppose they are innocent villagers, they do not know anything.
They are not coming outside. Sir,
Then
that is not
why
what.
are you
Because,
canvassing their case?
no, but sir, because you Higher Education Department, you see how they have violated, sir. Every point says age limit is not there. They have incorporated the age limit, and also they have not forwarded this copy to Bhavedi. I have already filed the RTI to the CPIO of this UGC. They have replied that appointment clause on contract basis, they have violated 30 point.
This notification was issued in the year 2019. We are now.
2019, that is memorandum, sir.
All right, whatever it is,
Achha, achha.
memorandum. You want to cancel the memorandum which was issued in the year 2019.
I have written, sir. I have already, OSD, same secretary already replied to me that matter relates to the hiring department. You contact with them. I'm showing you, taking you, sir.
And
1 minute, sir. 1 minute.
we can't entertain, sir. Sorry.
Sir, please say it. A lot of people are affected. A lot of students are affected, sir. They use a total violation. Total violation.
But what we can't set aside a memorandum issued in the year 2019, alleging that it is against UGC regulation issued in the year 2018.
UGC never told that part-time teachers do not have.
You are for the UGC.
No, my lord. I am for the West Bengal College Service Commission. This is the matter he had challenged the state aided college teachers who has been appointed and my lord, the engagement by the college in the my lord, since 2003 to my lord, up to 2019. Those are candidate my lord, service has been my lord, to continue up to 65 years by virtue of the 2019 regulation. My lord, more than 35,000 in the across of the state. That notification now he has challenged.
2019 notification.
Let me finish.
That is not, sir.
Yes.
That is wrong, they are telling.
No.
2020.
No.
18 July 2018, UGC notified. And
Lord, that is different. Let me finish first, then you.
I am telling you, you are wrongly informing. Na?
My lord, kindly see the notification prayer, my lord. Kindly see the prayer. Who has prayed for, he has prayed for cancellation of the notification, that is, my lord, 13 December 2019. That is notification, those guest lecturer and my lord, contractual lecturer engaged by the respective college of the across of the state, their service has been approved up to 65 years and their service is not.
You have not implemented.
They have not
followed the policy. Part-time teacher who do not have qualification.
The same and identical, my lord, the PIL, filed by somebody else, and lordship has dismissed on the ground that they have.
One second, sir.
They have withdrawn because without making their affected party 35,000.
That's a public interest. It's not a lot of people are.
No, you have to implement the candidates from 2018, 2003 to 2019. They have been working.
From 2010, it was taken, sir. No, sir. That was wrong. From there, most of the people were taken between 2006.
Well, kindly see the prayer of that PIL.
And knowing fully well.
Same and identical prayer. Kindly see that writ petition. Public interest litigation prayer. Well, kindly see the prayer.
I am not
Here,
I am not
the nature of man was directed respondents there submitted to cancel the memorandum, and then my lord, kindly see the earlier writ petition, public interest litigation.
That doesn't matter, sir.
This is not the way to submit.
You have heard the learned.
Sir, please, sir. This is violated, sir. Please violate it, sir.
Yes, sir.
Completely violated, sir.
We will consider it, sir. We have heard the learned advocate appearing for the.
They have no qualification. They were appointed.
Appearing for so and so responded. By this writ petition styled as a public interest litigation, the petitioner seeks to challenge a memorandum issued by the Higher Education Department, Government of West Bengal, on 23/12/2019, alleging that it is not in consonance with the regulations issued by the University Grants Commission, wide notification dated 18th July 2018. It is pointed out by the learned advocate for the West Bengal College Service Commission that identical prayer was sought for in another public interest petition in WPAP 363 of 2022, and the court the court heard the submissions on either side, and the writ petition was withdrawn. In any event, at this distance of time, the question of considering a prayer by a public interest litigant who stated to be an advocate practicing before this court to withdraw a memorandum issued on 23/12/2018 cannot be considered, and more so when none of the parties who are likely to be affected if such prayer is granted have been implicated as respondents in the writ question. Hence, the question dismissed.
Serial number 4.
Next.
My lord, this is my petition. May I take back, my lord, the writ? My lord, this was with regard to the seizure called by the junior doctor, which has been withdrawn on 4th of October. However, my lord, a more serious situation has arisen. From 5th onward, my lord, the 6 junior doctors have gone on an indefinite hunger strike. My lord, from now on till the 15th, Supreme Court, my lord, is on vacation, is not available. I am an informant.
Actually, our matter is coming up on 15th October. We can't entertain these very issues now pending before Supreme
Well,
Court.
Lord, one second, my lord. The issue which was before the Supreme Court was the seize work, not the hunger strike, indefinite hunger strike. If anything happens, my lord.
If you want to withdraw, you withdraw, otherwise you dismiss. We have heard the learned advocate for the petitioner. And the writ petition has been filed by an organization called Human Protection and Awareness Organization, claiming themselves to be public spirited persons and challenging certain decision taken by the junior doctors. The entire matter is seized off by the Honorable Supreme Court, and we deem it appropriate not to entertain any writ petition on the said aspect. Hence, writ petition dismissed.
We are grateful, my lord. Serial number 5.
Hence, not writ petition. Appeal. For no writ petition.
I am for the private respondent, my lord.
I am appealing for the National Commission for Scheduled Castes. I am for the petitioner as well as the applicant. My case is that I am not seriously aggrieved in the circumstances and my life is in the danger. In fact, the respondent, particularly the police authority, they are simply violating Article 46, Article 23, and even the speed of Article 226, they are not maintaining. Now, if your lordship kindly see, I being belongs to a scheduled caste category, and there is a dispute between me and the private respondent. And I went to the police station to lodging the complaint on 14th October 2023 at about 9:30 like this one. And up to 2 a.m., I was sitting in the police station. I do not find any officer. Ultimately, when the officer came into the police station, he then asked me, what do you want? Well, this is my complaint because the private respondent and his associates are torturing me and using very nuisance and all unparliamentary words upon me. You can take the steps, and this is my representation. Upon going to the representation, police authority says, we are not accepting this representation. Either you write a fresh complaint, otherwise I will take a stern action against you. Ultimately, they taken my representation from my hands. The main copy, 2 copies. One is the office copy and another is the original complaint which I intend to file before the police authority. 2 copies has been taken and ultimately they are threatening inside the police station, taking stern action, arresting me. And ultimately he then compelled me, yes, I am giving you the dictation, you follow, you then submit. Finding no other alternative, I make that representation. That has been annexed. But the original one, the 2 copies, that has been taken by
the complaint said to be given by you, not as per the dictation.
As per their dictation.
Some FIR has been registered, now charge sheet has been laid. There is a counter complaint given by the private respondent. In that also, charge sheet has been laid. That matter is before the trial court. Now, therefore, the learned single bench has said, you please raise all the issue before the trial.
Now, how myself I will be aggrieved? How myself I will be
interfere in a
writ? Well, lordship, kindly see.
If according to you, after this charge sheet has been filed, still the private respondent is harassing you, then you file a complaint.
Lordship, kindly see. I am coming to the order passed by the court below.
We have read the order.
Yes.
My lord, may I submit? This is a civil nature, my lord. Civil suit is pending in between the parties, my lord. This is the order. A status quo order, my lord. And in the meantime, it has been filed in the year 2022, my lord. Kindly go through that.
Page 2 of the order sheet. If your lordship kindly see. Kindly see the order sheet.
Yes.
It was duly signed by him as well as. This is the version that was given by the petitioner to the police for registering FIR, the petitioner. This is the version means the second copy. The first copy has been taken. That has not been recorded. And there is no whispering about this. And if aggrieved could not have waited till 6 November 2023 for the first time to it. This is the 6th November complaint. If your lordship kindly see, the 6th November complaint is the subsequent representation I made to the different authority, including police, including the chairman, National Commission, this. The court finding is that there is no whispering about this one. If your lordship kindly see, on the day, the sanction was granted by the superior authority to file the charge sheet. Lordship kindly see, the Calcutta police is now so.
Sir, how in a writ petition we can direct that the offence under the SC/ST Act should be included?
Yes, that is the point.
No, that we can't do.
Lordship kindly see, if your lordship kindly see, I intend to file the supplementary affidavit before your lordship. That will unfold the entire picture.
Madam, kindly allow me to submit my part.
Yes, supplementary affidavit. Not leave may be granted to file the supplementary. And give it act amendment bol di তোমাদের নিয়ে
কপি টা দিন
এর কপি কি হচ্ছে সাবমিট
অ্যাডভান্স কপি দেওয়ার ছিল
এই তোমাদেরকে পাঠানো হয়েছে
না কেউ পায়নি
তোমাদের পেয়েছে
না
হ্যাঁ
না
Yes, not been so.
Now, when was this complaint given? On 4th of September.
Now, if your lordship kindly come to that, the entire incident which has been taken place inside the police station, that has no record. Only the concerned CCTV footage, if that can be located. Yes, otherwise.
This complaint, page 4 of your supplementary affidavit, was given on 4th of September. What happened to that complaint? We will direct them to investigate that complaint.
If your lordship kindly help me to tell this one in supplementary affidavit.
Supplementary affidavit, page 4.
Page 4.
This complaint was received by the Posta police station on 4th September.
No, my lord. This is that point. This application, this is the last incident has been taken place for the sake of for unfolding the truth. How I myself, my lord, that page 4 is not to be taken, my lord.
Then why have you filed this page 4?
My lord, the last incident, few days back, another incident, that document has annexed herewith. If your lordship kindly see.
Sir, we will give you liberty as given by the learned single bench to go before the trial court and say that further investigation has to be done, SC/ST Act offence has to be registered, etc. Title suit is also pending.
Now,
yes, madam.
Now,
yes, madam. They are trying to use that SC and ST certificate, my lord, to evict me, not through the process of law. As there are kindly allow me. As there are several cases in between the parties, on the 15th October, there was case and counter case registered. As their case was numbered as 96 and my case was numbered as 97. After the passing so many days, they wanted to narrate another story in accordance with SC/ST. That is on 6/11.
Very well. Whatever my learned friends is, if your lordship kindly see the contents of my date application, if your lordship kindly see the CAN application 2, if your lordship see the writ application.
Page. CAN 2 page number.
Yes, my lord, I'm telling you. Para 5, page 4. Page 4. The story they are making before the court. If your lordship, This is the writ application which has been filed before the single bench. That the petitioner states that under compelling circumstances, the petitioner and his other family members, including his brother, went to the police station and contact the duty officer according to the advice of the duty officer. The petitioner went to the medical college examination. Thereafter, at 2 a.m., petitioner was able to meet the duty officer. Accordingly, the petitioner handed over a complaint contains a detail of atrocity taken place on the petitioner and his family. Be it mentioned, the petitioner has specified the hate speech using the respondent number 6 on the scheduled caste community. At the beginning, the said police officer asked your petitioner to hand over the complaint along with the second copy. Accordingly, the petitioner handed over all the copies. Upon the receiving the same, the concerned police officer started threatening. My same friend says on 6th November.
And this has been filed in December.
Please.
Lordship, kindly see the Honorable Single Bench has observed coming at the delayed stage. Finding the 6th November, I make a lodge complaint. But in the
You are not answering our question. When charge sheet has been laid, how a writ court can issue a direction to include an offence under SC/ST Act?
That is the prima facie object.
So therefore, liberty has been granted to go to the trial court to file for an application for further investigation.
One judgment I am placing before your
Ah,
lordship.
yes, you place. You are before the wrong forum.
The case of Anand Tharun Karmuzi versus State of Maharashtra. Well, Lordship, kindly to the para 11. This court has a wide power in invoking Article 226, and Supreme Court can invoke in Article 32. This writ court is having wide power at any stage, further investigation, re-investigation, de novo proceeding drawn up. All the powers are in the hand of this honorable court invoking Article 226. My lord, I am appearing in the writ jurisdiction. Now, this reference, why I am making this honorable court? Because 226 is having.
Sir, this was a case where they wanted the investigation to be transferred to CBI.
My lord, ultimately, my lord, our section, our application in the reference, second application, we also make a prayer before that. If the court.
Your writ petition is to give effect to your representation dated 6/11/2023 to arrange for necessary protection for the petitioner and the family members and to set aside the FIR dated 15/10/2023 and draw up a fresh FIR. The court considered the prayers and found that the FIR is now, investigation is over, charge sheet has been filed. Counter complaint, charge sheet has been filed. Therefore, they gave liberty to go before the concerned trial court to seek for further reliefs. What more can be done? So far as any threat is concerned, there we will give you liberty. Suppose if after this order, if he is threatening you, that the police will separately investigate that. If there is a threat perception, they will give you protection subject to payment of cost for that protection. This intra-court appeal by the writ petitioner.
One prayer before. There is a 4 days delay. 4 days delay we can also be condoned. 4 days delay.
This intra-court appeal filed with the writ petitioner is directed against order dated 2/5/2024 in WPA 26175 of 2023. There is a delay of 4 days in filing the appeal, and since the explanation offered is acceptable, the delay is condoned. The writ petition was filed to give effect to the petitioner's representation dated 6/11/2023, semicolon, to provide protection for the petitioner and his family members, and to set aside the FIR number 97 of 2023 dated 15/10/2023 and draw up a fresh FIR upon fresh inquiry. The learned writ court, upon considering the facts, found that the FIR has now matured into a charge sheet, and charge sheet has been filed before the learned trial court. That apart, there is a counter complaint given by the private respondent, in which investigation was complete and charge sheet has been filed, and both matters are now pending before the trial court. Therefore, the learned single bench rightly observed that the writ petitioner shall be at liberty to agitate all points at the time of trial, comma, if the same ensues, ENSUES. It is submitted by the learned advocate appearing for the private respondent that civil suit is pending between the parties in title suit number 2608 of 2022 before the learned 8th bench City Civil Court at Calcutta. And there is also an order of status quo. The learned advocate appearing for the petitioner placed reliance on the decision of the Honorable Supreme Court in Anand Tanur Karamse, so-and-so, Civil Appeal number 13 of 2023, dated February 24, 2023. We find the said decision will have no application to the facts of the case, as the matter before the Honorable Supreme Court was whether the prayer for transfer of investigation to the Central Bureau of Investigation was justified or not. Therefore, we are of the view that the learned single bench was right in disposing of the writ petition with certain observations. Dismissed the writ petition with certain observations. If, according to the petitioner, he and his family members are continued to be threatened by the private respondents, even after the charge sheet has been filed before the learned trial court, it will be well open to the petitioner to file an appropriate complaint before the jurisdictional police, who shall consider the complaint and cause an investigation and assess the threat perception. And
one prayer before your lordship, subject to the leave of the court, my lord.
Yes, sir.
Supreme only if your lordship kindly include the Supreme Court guidelines given in the Dharampal versus Bharati, where even says a de novo investigation even after the charge sheet is filed.
Yes.
That can, if your lordship say.
Yes, sir.
My lord.
Thank you.
One thing, my lord, as I have not received the supplementary affidavit, I have not.
You ask your friend.
I am denying, my lord, the contentions. And second thing, my lord, kindly note it down that the brother of the petitioner, namely Ritesh Sonkar, has also filed a writ petition with the same cause of action, being writ number 5313, WPA number 5313 of 2024.
The learned advocate appearing to the private respondent submitted that the copy of the supplementary affidavit.
But we do not have any knowledge.
And private respondent does not admit any of the allegations made there. Further, it is submitted that the brother of the writ appellant has filed another writ petition on the self-same cause of action in WPA
5313, madam.
Of 2020.
5313 of 2024. Grateful, madam.
Next.
Serial number 6. Deprobation.
State respondent.
Your Lordship, I appear for the appellants.
I appear for the petitioner respondent.
Your Lordship, I was humbly praying that the matter could be taken after the vacation. Your Lordship had observed that the matter to appear on 4th. Mr. Bera is appearing in this matter. He is not available today.
The difficulty is, my lord, the petitioner is a judicial officer who was posted on deputation, my lord, as competent authority under the Metro Rail. Discharge his functions. Now, my lord, for the period of enhancement, as per the Shetty Commission recommendation, all the judicial officers in the state, everybody under your lordship's guidance, they have got the arrears, except this officer. They are not paying by saying that you have to refund the benefits received at the railway, then only you will get the arrears. The Supreme Court has said it has to be paid to all the judicial officers. Everybody has got it. Your lordship has set up
As per the
committees for...
DOPT guidelines, your Lordship, an officer is who is in deputation is given two options, two times, an option to opt for state government's pay or the central government's pay. This particular officer first initially asked for state government pay. In 2023, he asked for the central government pay. And thereafter, he again chose that as per the Supreme Court's guidelines, when the pay had increased, he is asking for the state pay.
Because
And furthermore, next time when the central government puts in 8th pay commission, he is not given that option. He does not have that option under DOPT guidelines, particularly circular number 57, stating that he can opt third time.
No, this is not option, my lord. This is deputation rule. Deputation rule says, my lord, one.
If in the parent cadre, the pay has been revised, and the benefit is also extendable to a person on deputation. Or I can do one thing, on the administrative side, I'll withdraw him. I will say, no, there will be no railway magistrate. Then what will you do? Where will you go?
Now he has been transferred, my lord. Now
He's back to the
parent cadre. But for that period, not the rule is that if there is a refixation or upgradation of pay in the parent cadre, there shall be corresponding refixation in the central government scale. That is the rule. They have annexed.
See, he is the state government, or the state government is the lending department. You are the borrowing department. So if he has got a comfortable AC room in the lending department, borrowing department also should provide him this.
Your Lordship, same page. Your Lordship, page number 30 of my stay application, point number 3.3.
No, this is not you're right. Option once exercised, some rules give him one chance to revise. Some rules say once till your retirement gone is gone. But here it is not so. It is pursuant to a direction issued by the Shetty Commission. We are bound to implement. If you don't implement, then the High Court will be and the state government both will be on contempt.
Your Lordship, allow me to come back after the vacation on 4th on the reopening date, as my senior is not there and it's a changed brief.
Who's your senior who's going to appear?
Your Lordship, Mr. Bera, who was all along handling this matter, I have been appointed only 2 days back.
At the request of learned counsel for the appellate.
Much obliged.
Sometime in 3rd week of November.
Serial number 7.
Yes, my lord. My lord, this is the affidavit on service. Everything has been served. My lord, my contempt petition application was dismissed. I had some objections regarding it. That's why I filed this appeal. There was a direction on the police authority.
No, where is the certified copy of the order?
I don't have the certified copy. I took a leave from you.
No, server. At least you have to file server copy. Without anything, how?
I've given the server copy.
Server copy is there.
Server copy is there, my lord.
Suppose certificate copy is not given by the department. Have you applied for the certificate copy?
Yes, I have applied, but did not get till now. There was a direction upon the police authority to investigate the case properly, but the police department did not investigate the case properly.
No, the learned single bench. See, it is a contempt application. Contempt application, they considered that investigation has been done, charge sheet has been filed. So you are the de facto complainant. So you advise your client, or you are the party in person. You know your rights. You can always go before the trial court saying that no, this is not the manner in which investigation should have been done. We want fresh investigation to be done.
But there was a direction to investigate the case properly, and they did not do that.
This intra-court appeal is directed against order dated 9/7/2024 in CPAN 152 of 2024. The learned writ court, after considering the factual aspects, found that the police and the investigation agency have conducted investigation and filed a charge sheet against the absconding accused. And it is quite obvious that necessary consequent steps would follow in due course. Therefore, the court is of the opinion that no contempt is being made out. We find no valid reason to interfere with this order. Dismissed. Sorry, sir. Next.
Serial number 8.
This is my appeal.
I'm appearing for the appeal. This is the affidavit of service. My lord, the case is this, my lord. The trade circular has already been issued, being annexure P2 and page 24 of the first volume. And here, my lord, actually, my lord, the tender has been challenged at because it was not published in GEM. And my lord, under the general financial rules, all the central government CPSUs, my lord, public undertaking, central government public undertaking are required to enlisted and required to be enlisted, as well as, my lord, these are required to be published before the GEM, following the guidelines, my lord, issued under the general financial rules. My lord, I am referring the particular guidelines as annexed with this.
No, this is against an order.
An interim order. The order is, my lord, at starting from page 20, my lord, after
Sir, the tender has already been awarded. Work is in progress. Learned single judge says it's in the verge of completion. Yet the learned judge said, call for affidavits. And you see the last paragraph. It is made clear that any action taken in the meantime shall abide by the outcome.
My lord, the thing is that, my lord, why this is the exigence? There is an exigency.
You would have mentioned before the bench.
My lord, I have.
Because they have not upgraded the matter, you filed the appeal.
My lord, kindly expedite the matter, my lord.
All right. This intra-court appeal by the writ petitioner is against an order dated 18/4/2024, by which the learned single bench declined to grant any interim order. The learned writ court found that the work has already been awarded by the respondent, and the same is already in progress in terms of the tender and is in the verge of completion. Therefore, we are of the view that the learned single bench was right in not granting any interim order. However, we note that the learned single bench has directed the respondents to file a report by way of an affidavit disclosing the relevant documents and pleadings, which are pertinent to the arguments advanced by the parties. A time frame was also given for filing such a report. The writ petitioner was permitted to file their
yes, my lord, affidavits are all complete.
Rejoinder. It is admitted by the learned advocate appearing for the appellant that the pleadings are complete. Therefore, at this juncture, we do not propose to interfere with the impugned order, and the appeal is dismissed. The petitioner is at liberty to mention before the learned single bench.
My lord, let this matter to be considered by the learned single bench, my lord, within 2 weeks after vacation.
Honorable Supreme Court
for
has
an early
already
hearing,
said your time frame cannot be
during
fixed.
third week of November 2020. Next.
I'm grateful.
Number 9. My lord, kindly expedite the matter, my lord.
Yes, we have said.
Yes, grateful, my lord.
My lord, item number 9, I am for the appellant, my lord. All services have been not completed yet, my lord. Praying for
What
not
is the
today and
matter?
time.
Let us see if service is required or not. This order says, counsel appearing for the petitioner prays leave to withdraw the application.
My lord.
Accordingly, it was liberty was granted to withdraw with liberty to file a contempt petition.
Contempt petition, my lord. My lord, all the private, particularly the private respondents, all the services has been not been completed yet, my lord. Kindly fix the matter 1 week after vacation.
No. How we can interfere with it? You are a changed, it's a changed brief.
My lord.
Then this intra-court appeal by the writ petitioner is against order dated 9/9/2024, which reads as follows. Please quote the entire order. Yes. We find that the learned counsel appearing for the appellant writ petitioner submitted that the writ petitioner prays leave to withdraw the writ petition with liberty to the petitioner to file a contempt petition. Accordingly, the writ petition was dismissed as withdrawn with the liberty sought for, and liberty sought for was granted. Now the appellant has engaged another counsel and has now referred this appeal. We find that this is no ground to entertain this appeal. Dismissed. Sorry, sir. Next.
Serial number 10.
Lordship, I am on behalf of the appellant. Advocate on record suffering from high fever. In this reason, he is not able to court. Kindly fix another date, Lordship.
No, Deputy Commissioner of Police. This matter, we can't interfere, sir. Where is the boundary wall? Where police, can you do it?
Lordship, I am not.
Then don't represent. This writ petition is directed against an order dated so and so, person WP so and so. The appellant alleged police in action. The learned writ court considered the averment set out in paragraph 8 of the writ petition and found that the police authorities is not vested with the power to decide the boundary line of an immovable property. The full stop. The stand taken by the learned writ court cannot be faulted and no ground has been made out to interfere with this dismissal. Next.
Serial number 11.
Good morning, my lord.
Yes.
Yeah, my lord, at annexure P1 11 page, I have applied for the original order, and you have given a granted a leave for apply through net copy of the order where the case is dismissed and disposed. Apart from recovery of order, my lord, I am also seeking. My privacy is totally under threat. And if you see page number.
No, madam, your writ petition is dismissed for default. You file you file application before the single bench for restoring your writ petition. Appeal is not maintainable.
I have appeal because it is disposed also, my lord. This is the reason I have approached to you. Because it is not only dismissed. If it could be only dismissed.
We will clarify. We will clarify. We have heard the petitioner appellant appearing in person. The appellant is agreed by the order dated 5/7/2024 in WPA 28839 of 2022. In the said writ petition was dismissed for default. Though in the last line, it is stated that the writ petition is accordingly disposed of. That would mean that
the video conferencing was not available at that point of time.
No.
That
We will give you liberty. Disposed of accordingly would mean that the writ petition.
My lord, one more thing. My lord, one more thing. After release from Mantha Sahib court, there is no police has not filed any type of complaint. Nothing. There are multiple orders happened, but nothing. Even in Delhi also.
We will give you liberty, madam. We will give you liberty.
Madam, my lord, I have also applied for a change of bench also, my lord, because I want somebody should take care of this complex matter is also involved of murder, my lord. A murder from call recording.
To file an application before the learned writ court for recalling the impugned order and restoring the writ petition and hearing and to decide the writ petition on merits and in accordance with it. We dispose of it. That's all. Thank you.